Next case on the docket is PERAZA versus MAZAKII.
Come on.
Good morning, Your Honors. Please the Court. Omar Medina on behalf of the appellants, Rebecca PERAZA. Your Honors, the appellants in this case, this is a summary judgment motion that was granted over the plaintiffs below's request for continuance of the motion for summary judgment to conduct some further discovery.
How much time had the plaintiff had to conduct discovery prior to the summary judgment motion?
The case was filed in February of 2007. The summary judgment motion was granted the hearing was held in May of 2008. Order entered June of 2008, June 9th, 2008.
What discovery did the plaintiff want to do that they couldn't get accomplished during those 15 months, and why couldn't they have done it during those 15 months?
For 4 of those months, Judge, I was the plaintiff's counsel, and I had a brain tumor that I was dealing with, and so I was out of commission from just before October through December. Couldn't read for long periods of time, things of that nature. The discovery, we were thwarted from the very beginning, and I think this is where the trial court was confused by counsel below's assertions. Very early on, and I think the record will back up on this, is the first discovery submitted by the plaintiff, everything was objected to, nothing was given to us. We sent a letter to the plaintiff's counsel, to the defense counsel attempting to resolve those issues. They were not. No discovery was granted. We were not.
I'm sorry. Was there a hearing and it wasn't granted, or
there was
a hearing? Okay.
There was a hearing. They didn't get to it. We tried to resolve the issues. There is a letter contained in the record at 126, 127 to a motion that sets out that this was in October of 2007, saying, "Hey, look, I want to take the defendant's depo, giving a bunch of dates. And you can take my client at the same time. Our offices are in Tampa. I'm willing to, let's do it in Tampa so we don't have to go up to Sumter County." There was an objection to taking a named defendant's deposition in this case. This was Rebecca PERAZA versus Paul Mazak, Reba Mazak, and Mazak Properties situation. We tried to take Reba Mazak's deposition, objected to. We tried to take the parents' deposition of Mr. Mazak, who's the largest property owner in that county, has cattle, objected to. We tried to take the deposition of EMS personnel. It was difficult taking those depositions.
Did you have all those depositions before the summary judgment?
No. The deposition of Reba Mazak, we had to file a motion to compel, and that order on the motion to compel the deposition of Reba Mazak was entered in April of 2008. So less than 30 days before the summary judgment hearing. And the question
did you have her deposition or not?
Pardon me, sir?
Did you have her deposition or not?
It was taken in April of 2008.
That was my question. My question was, were any of these what you didn't have prior to the summary judgment hearing?
Yes, we did not.
I don't want to hear why it took you till April rather than October. My question is, as of the time of the summary judgment hearing, what were you still missing?
We were missing the deposition of the Mazak parents. We were missing the deposition of adjacent property owners.
What kept you from scheduling and taking the deposition of the adjacent property owner whenever you decided to do so? The other side has no control over that, correct?
Yes,
They
sir.
can't object and keep you from subpoenaing and scheduling the deposition.
That's correct, Your Honor.
So why didn't that get taken before the summary
Scheduling of
judgment?
the defense counsel wouldn't clear the dates. And we filed our motions to compel, and the record will show that we filed, the plaintiffs filed, and as early as October of 2007, we took it upon ourselves.
So you're saying the defense counsel was the problem, just wouldn't clear the dates and wouldn't cooperate? Is that right?
We could not get dates cleared. That's correct, Your Honor. And we had to file motions to compel, and we did. We filed a motion to compel the depositions of, and to clear deposition dates that the record reflects was filed after I came back from my illness. And we kept asking for dates, and we kept...
I'm confused why that leads to a motion to compel. If you try and get dates from the other side and they won't give you dates, isn't the remedy you set a date, and if they want to move for a protective order, they can, but you go forward with your deposition? Why do you have to even file a motion to compel?
Your Honor, that's typically, and it's interesting you say that, because that is, I get varying degrees from trial courts, because that is typically how I do it, but then I get tongue lash, if you will, when I do that, because typically what I like to do in my practice is we ask for clearing of dates verbally. Then if we don't get a response, we tend to, either nowadays, we send an email and say, hey, look, I'm asking for some dates. If you don't give me dates, I'm just going to set it. And I did this in this case, and I got a motion and a tongue lashing from this judge at a hearing saying, why are you setting depositions without clearing it with the other side?
All right, as to the adjacent landowners, did you ever show the trial judge a letter saying we would like to take depositions of the adjacent landowners? I have, these dates are my preferable dates.
Yes, there was dates, and there was a letter to the judge, and I think very early on, Your Honors, I think what happened here is early back in about 2 weeks after my surgery, there was a telephonic status conference hearing, and there was a letter that's contained in the record at 126 that I wrote to Judge Morley. And in that telephone conference, she apparently had trouble hearing me, and I could hear her, but she couldn't hear me, and she accused me of acting, she said, unprofessionally, and that she was talking upon deaf ears. And it was just a bad communication, and I wrote it, and it's set forth out in the record, and say, I'm concerned that the court was misinterpreted here, because I just couldn't hear you, and neither you or Mr. Shealy could hear me, and that was not the case. And I said,
did opposing counsel ever give you dates back saying we can make it on this date, or we'd be happy to do it on this date, or were you just giving them dates and they said no and they didn't give you any dates back?
I suggested dates.
Did they give you dates back that they could make it?
For some of the depositions, yes, Your Honor.
The deposition that we're talking about, the adjacent landowners.
No, that never happened. We could not get that done at the end. When I filed in we've been trying to take MAZAK, Mrs. MAZAK, defendant MAZAK's deposition since October 2007. Filing our motions to compel, which is in the record, and we finally got an order from the court in April. We took her deposition in April. I asked to take the adjacent landowners' depositions, denied.
So you're telling us that you wanted to set the deposition on certain dates, relayed that to opposing counsel, and opposing counsel just said no and never gave you any dates in return that would be convenient for them?
Yes, Your Honor. And if you'll see the attachment of our motion to compel deposition dates, which was filed in January of 2008, and Mr. Shealy's response to us, in his letter, which I've attached as part of the record as well, in it he states, that we don't want to give you Mrs. MAZAK's deposition, and yes, we're working forward to, I've received your request for EMT personnel and the investigating officer, and we're trying to get dates for this matter. And my position is, I have been accused of, in this case, for the first time ever in my career as a plaintiff, because our position always, let's move. I understand that nothing gets happened until we get a trial date. I am pushing for these dates. I'm moving forward despite my illness, despite what was going on. This has been, at this time when we find these motions to compel, less than a year that's going on. We take the investigating officer's deposition, and despite all that, Your Honors, in this case, it's a Warren Act case, we filed with the court for a defeat of the motion for summary judgment, we believe, which gives us under the law that I won't recite, the court is well aware of the summary judgment law in this district, as it is in the state of Florida. If there's any issue.
Okay, let's move on past the, the discovery issue and the fact that you didn't have enough. Let's just look at the record that we have.
Yes, sir.
All right, and the issue is, who did the cow belong to, right?
I'm sorry, Your Honor.
Well, the main issue is, who did the cow belong to? You
Yes,
need
sir.
to know who to sue, right?
I think the main issue is, it's one, who the cow belonged to, and two, had that occurred in the past.
Was there negligence or a violation of the act, right?
Yes, sir.
Well, you have to establish who the cow belonged to in
Yes,
order to
sir.
establish a breach of duty. So what evidence is there in the record that the cow belonged to the defendant?
The testimony of the police officer, the investigating police officer, Deputy Wilson, which, by the way, also, Your Honors, we set him for, just to show you how this was taking time, we set his deposition, we drive up to Sumter County, he doesn't show up.
Excuse me, he didn't know who the cow belonged to. He was just relaying what was told to him by others, isn't that right? He didn't have any firsthand knowledge as to who the cow belonged to. He was just saying, this is what I was told and this is what I put in my report.
No,
And then as it turned out later, I mean, the defendant denied that it was denied that the cow belonged to him.
I believe that what Deputy Brown testified, that when he came up to the scene and he had the cow and he called Mr. Mazak, and at the scene, Mr. Mazak, the cow was on its line where he couldn't see its brand, and it was a time where he could not see it.
Right.
And he asked Mr. Mazak to move the cow. Mr. Mazak didn't deny that it was his cow.
But the point is that the police officer didn't know who the cow belonged to. The police officer was just putting in his report what other people had told him. Isn't that right?
No, I think he didn't talk to anybody else. The police officer only talked to Mr. Mazak and my clients involved in the car. He called Mazak.
Are those conversations admissible in evidence?
I'm sorry, I'm having trouble hearing. That's
Are
part of
those
the-
conversations admissible in evidence?
There is a exception to that, and it would not be admissible.
Right. Don't you have to present admissible evidence to contravene a summary judgment? You can't present inadmissible evidence, right?
That's
You
correct.
can't convene just on hearsay, for example.
That's correct. But
What admissible evidence was there to contravene the defendant's position that it wasn't his cow?
again, Your Honor, we believe that the admissible evidence at this point in time would be I disagree with the court. I think Deputy Brown did testify in his depositions at pages 20 through 23 that at the scene when he said that he told Mazak it was his cow and that there was no objection. I believe a jury can't.
Sorry, I thought you said that wasn't admissible. You're saying that is admissible evidence?
Well, I think his conclusion that it was his cow, and I think in the report he concluded that it was Mazak's cow, and I think he did make that conclusion in his deposition.
That was based on what Mr. Mazak or the defendant told him. He didn't know firsthand who the cow belonged to. He was just putting in his report what others had
That's
told
correct.
him, namely Mr. Mazak,
That's
who was
correct.
the defendant.
But, I'm not sure, as I'm standing here now discussing this, I'm not sure that in a situation involving an animal and livestock, in this case, given that Mazak is removed, depending on what position he takes, that he would be part of the accident report privilege as far as ownership is concerned. I'm not sure the statute. I didn't look into that for this brief. That's
Okay, so the statements made by Mazak that would be admissible that related to the ownership of the cow was what? He said, that's my cow, and 5 minutes later he said, oh, no, it's not?
Well, he didn't say, oh, no, it's not, but let's take it to the next level. In an automobile accident case regarding ownership of the vehicle, I'm not sure that those statements would be inadmissible. I think how the accident happened I think that's what the statute and what the legislature is trying to do is protect and want us to be free and forthcoming as to how an accident happened so there was an investigation. But I'm not sure ownership would be part of that. Again, I haven't briefed that, but I'm just throwing that out there.
Well, if a person gives conflicting statements, that's something that you can use to impeach them with or to test their credibility. But that doesn't necessarily establish ownership.
And that's why...
That's what you have to do here. You have to establish a breach of duty, and to do that, you have to establish that this particular person that you're suing owned the cow. And there's no evidence that this person owned the cow, because there was evidence that neighbors and other people own cows just like it.
the nearest neighbor was 5 miles where they were.
Isn't that their position, that it's not our cow, but there are other people that own cows just like it?
Right, but I think the court's, your very questions are why this case was prematurely ruled upon. Because part of the other things and the other discovery that we needed to do, we were at the very early stages. There are records maintained by the county and by the state.
After 15 months, you were at the early stages? After 15 months?
Well, Judge, I think it was only at that point in time. I mean, I think the court needs to reflect on the roadblocks that were thrown against me. I mean, everything was objected to, and I filed a motion at every turn. And then what we need to do is, you're right, we need to get records from the state, records from the county, and try to track down every cow.
Why couldn't you have gotten the records from the state during the, what roadblocks kept you from getting the records from the state? The opposing counsel can't keep you from sending those out, can they?
You're right, Your Honor, but the first thing was learning who was the MAZAKs and trying to get to them, the parents. There are renters on the property that I wanted to take their depositions as well, people that they rented trailers to. I wanted to take those depositions. That request was denied as well. And then during this whole time frame, there was the motion for summary judgment was pushed forward upon me, and I tried to keep getting continuance, and the court will only carve out a few dates for me to take depositions. And then with the schedule of Mr. Sheely, who was underlying trial counsel, nothing was cleared for us. And I think in the Supreme Court guidelines is a year. This was, quite frankly, when the motions, we filed motions to compel in December and in January. And given the fact that underlying counsel, I'm out for 4 months.
What evidence is there in the record? Let's just go back to the record. Besides the officer that put in his report what Mr. Mazak told, what other evidence is there in the record that the defendant owned the cow?
Your Honor, in the record, other than the testimony of the deputy and Mr. Mazak, because again, his testimony was not that the cow wasn't his. His testimony was that he didn't know. And I think in this case, and I think you're defeating the claim at every point, a plaintiff would never have a case then. Because if I come in and say, oh, it's not my cow, it's not like there's a VIN number on a cow. Mazak went over, if it wasn't his cow, he went over there. He spent the money. He picked up the cow. He drugged the cow. He buried the cow. These are all things for an animal that's, 1,500 pounds that doesn't belong to you. A couple hundred yards from your thing. And then, so we're looking at that, and then I have a lady driving down in front of his property. His cow gets out. It's gotten out in the past. The deputy's testimony was that Mazak would leave the gate unlocked because deputies were constantly herding cattle back into the property. And that's at Brown's deposition. So to say, hey, look, you can't prove by a VIN number that this was your cow, I think that is the question of fact, ownership for a jury. I don't think that is a legal matter as to ownership, because in such a situation where we can't prove ultimately or affirmatively through a VIN number or anything like that this cow is his, what is the circumstantial evidence? And the circumstantial evidence is proximity to his gate, proximity to the cattle crossing. It's happened in the past. He gets called out there. There's no other place for cows to get out from his neighbor that's within 5 miles.
Well, you apparently had brands, right? You don't have VINs, but you had brands according to the defendant's testimony. All of his cows were branded. There was no evidence that this cow was branded, correct?
Okay. And if that would have been the case, and that would have been the order would have been entered, and if I would have been able to litigate this case, and quite frankly, Judge, I litigate all over the country, and this has never been pushed on me so quick on all these in my experience, and because what I would have done in that case, if that would have come down from the judge and he did it, and then I would have said, all right, let me amend my complaint so I can file a motion for spoliation, amend a complaint, have a count for spoliation against Mr. Mazak, because if it's not his cow, he has nothing to do about it. He destroyed the cow. He's the one that buried it. He's the one that got rid of it. And so if I'm hearing the arguments or the suggestions of the court is, if I go and there's evidence that this occurred and I get rid of the evidence and now my plaintiff can't prove exactly whose cow it is and you're not going to let a jury decide upon the circumstantial evidence, we're out.
I thought his testimony was that he just dragged the cow to the side of the side of the road. Not that he buried it, but he just dragged it to the side of the road.
He dragged it onto his property, not to the side of the road.
Okay. Let me ask you about the discovery issue. Is it
Yes,
your
sir.
position that, excluding your illness, that 100% of the discovery delays were attributable to opposing counsel?
Your Honor, there is never, in any situation, 100% attributable to anybody in anything. I mean,
How much deference do we give to the trial court judge? Because it seems to me there's a lot of arguing and finger pointing between the two of you, and the trial judge had to make some determinations. How much deference do we give to the trial judge on that issue?
Well, I don't think, in this case, Your Honor, that Judge Morley, I understand the appellate courts, and you should give some deference to the trial court, but, there is no bright line standard of what they were saying is, I understand their arguments, I understand my time is up, but my understanding their arguments is that I somehow abused discovery. And I think if the court looks at the record and sees how from the very beginning we filed discovery, it was objected to, this judge isn't the easiest to get in front of her calendar, we get in front as quick as we can, we have motions to compel, they're ruled on, we're still not getting dates. What I'm hearing the court is go ahead and start setting things unilaterally. And you know what? That's what I did in a case, and that's what Sheely did, and he argued to the judge and wanted to sanction me for doing that. Exactly what you suggested, Judge. And then he starts bad-mouthing me to the court, saying, why am I setting things unilaterally? And
I think there's a difference between sending letters saying, I'm available these 5 days, I'd like to set discovery, and then the person says, I'm not available any of the 5, and then you going ahead and setting it, versus you not contacting them at all and just setting discovery. Most attorneys don't have a real problem working these type of things out.
I understand, and Mr. Sheely's a young attorney, and I've sent there's just not one letter. There was various letters. My experiences in the products case, and as the court's probably aware, getting depositions set with auto manufacturers is incredibly difficult. That's why I have my office practice is usually send the letter. We did that. We got a roadblock. I said it unilaterally, and I got drugged before the court, and the court said, don't do that. Work it out. I tried to work it out. I wasn't abusing anyone's time or discovery. I had deference to Mr. Sheely. If you'll see my letter of October 26th.
Well, you had a few letters that didn't look like they had much deference.
That's correct.
You accused him of childish behavior. You told his client he had a bad lawyer.
I didn't tell his client he had a bad lawyer.
Okay. You called him a small fish. You said, I'm sure your partners aren't going to let you try this case. There were a lot of pretty unprofessional comments going forth in this case, right? Would you admit?
That's right, Judge, and I shouldn't have done that, and I let him get under my skin, and that's wrong. But I also get under my skin is the behavior of his client and how Mr. Sheely let it happen, and it was racist behavior on his part, and quite frankly on the part of some of the deputies in that courtroom against me. And I didn't care for it. And I'm sorry that got under my skin, and you know what, that'll never happen again, but that still isn't, if you want to punish me or sanction me, that's one thing. But to take away my client's rights, when we were trying, and if you really look at the record, and you have your law clerks go back, and you look at the motions to compel, and I filed the status of discovery to let this court know what I was trying to do to get things set. There's not one letter from the defense counsel saying that you're not providing discovery to us. There wasn't anything, allegations that I didn't cooperate in getting things done. It's to the contrary. And I really don't understand, and now we're getting into the situation of perhaps there was the ownership, and I understand the court's concerned with that, and all I can tell you is if that is true, I would have asked to amend the complaint for a spoliation case.
Thank you, counsel.
Thank you, Your Honor.
Go on.
May it please the court. Good morning. My name is Mark Tinker. I'm with Banker Lopez Gassler in St. Petersburg. I represent the appellees. I'd like to just kind of address the issues as they occurred during Mr. Medina's argument and actually kind of looped back around at the beginning again with the primary issue being the timing of the summary judgment and the discovery that was outstanding. I know as Mr. Medina said, I wasn't trial counsel, and a lot of what was argued just now was a lot of things that probably aren't in the record. I know there are a few letters in the record outlining scheduling issues or whatever, but as far as perhaps the two offices contacting each other, whether people would agree to dates, I don't see those in the record. I mean, all I know, not being trial counsel, is what I do see there. It's the same thing that the court can see.
Well, what's in the record as far as the plaintiff's attempts to schedule depositions that were unsuccessful?
What I think are the key things, and bearing in mind this is what you got to at the end of the argument, is this is a discretionary ruling for the trial judge. This court would have to determine that no reasonable trial judge could go forward with this hearing under the circumstances. What I see is not only the 15-month delay, I think the big thing is this case was noticed for trial. The summary judgment hearing was originally set within the week of the discovery cutoff date.
Who noticed it for trial, the plaintiff or the defense?
I believe Mr. Medina did, but he'll correct me if I'm wrong without me having the record in front of me right now. But I believe the plaintiff noticed it for trial. The original discovery cutoff date was days, I believe it was 5 days after the original hearing date. The trial was originally set to be 3 weeks after the original hearing date. And then more importantly, when it got there, the day before that hearing, Mr. Medina filed his first motion for a continuance. The judge granted that, gave him a continuance, said you can do some extra discovery between now and the new hearing date. He said, that's fine, I'll get it done. Judge actually gave him a second continuance beyond that before actually considering the motion. So looking at all that and the entire history of this case, including the issue of the removal to federal court, the plaintiff attempting to remove his own case to federal court after it's been pending for almost a year, those sorts of things that I think were delays not attributable to the defendants. They're entitled to have their motion heard. One of the other things that kind of stuck out to me in argument is when the court asked what was the discovery that needed to be done, what were the extra depositions that need to be taken. And the two things that were mentioned were the adjacent landowner, and first of all, think that might be an issue that if you look at it now in retrospect is something that's not relevant to any of the issues on this appeal, because there's two things a landowner is going to say. Yes, that was my cow, in which case there's no case against Mr. Mazak, or no, that wasn't my cow, in which case we've got 50-50 chance. Well, it could be one of the two cows, or it could be some of the other.
Well, you might say, no, it's not my cow, it's Mr. Mazak's cow. I recognize it.
Well, on top of that, I suppose there's no evidence that he even saw the cow ever, and the only person who showed up...
There's no evidence because there's no deposition.
Correct. There is affirmative testimony that the only person to show up that night, the trooper testified he called a few people. The only one to show up was Mr. Mazak. I guess he didn't get a hold of anybody else. So Mr. Mazak was there, looked at the cow, originally thought it was his, then said he couldn't find a brand, said it's not mine, dragged it off.
Well, it's speculation at this point. We don't know if somebody came by later after the officer was gone and saw the cow and recognized it. So that would all be speculation. Right?
Correct.
Was there an objection to the taking of the deposition of one of the named defendants?
From what I saw, there was an original objection, something to do with REBA Mazak, because she wasn't, and this is going from memory now, she wasn't available and didn't know anything about, she doesn't have her hands in the farming operation at all. She doesn't know anything about the cows. That was eventually resolved. She was deposed, and she testified to that effect, that I have no idea about any of the issues related to the farm, and that deposition is in the record. It was there before the hearing.
I want to make sure I've got the chronology right. You indicated that the notice for trial, notice that the case is at issue and ready to be set for trial, was filed by opposing counsel. Is that correct?
I believe so, yes.
And then after that, the two continuances were granted by the trial judge. Is that correct?
Correct.
It used to be when I practiced law that when you noticed a case for trial, that meant that the case was ready for trial and everything had been done, discovery had been taken. Is that basically right? And then when you file that notice for trial, that's a declaration that you're ready to go and asking the trial judge to set it. Is that correct?
Having never been a trial lawyer, I agree that's my understanding as well.
You've never been a trial lawyer? You never tried a case before?
Never tried a case.
Okay.
You think it's more fun to be here?
I personally do, which a lot of people think I'm strange for that, but I do. The second issue that was discussed is getting to the merits of the Warren Act claim, and really the only thing that was talked about is the ownership. Again, the only evidence of ownership, it was the police officer's conclusion. That was based upon Mr. Mazak's original statement to him that he thought it might have been his cow, and then he decided that it wasn't, not seeing the brand. That is privileged. It's inadmissible in any civil proceeding, so it's not admissible as evidence. There is nothing that would be admissible in this case. It's in the record. Counsel discussed a couple things as far as Mr. Mazak dragging the cow off the road. Your Honor was correct. He didn't bury the cow. He said that he was out there with his truck. It was partially obstructing the road. He dragged it off into the field, and he said that that's actually just standard industry practice. Once a cow has been hit like that, it's not good for anybody. Nobody can use it for anything. It can't be turned into beef because it wasn't slaughtered in a sanitary environment. It's essentially roadkill. He said they drag it out for the buzzards, and that's what everybody in the industry does. So that was the only issue there. There was also a statement that the nearest neighbor with similar cows was 5 miles away, and I don't believe that's correct. Mr. Mazak testified that this was a black cow. He said he raises black, red, and white cows, but actually the gentleman right across the street from him, which was on the other side of the road where this happened, also raises black cows. So there's somebody right across the street that owns the same type of cows. The final thing that I just wanted to address is that's all the discussion that happened here today was ownership. And under the Warren Act, it's not enough for him to just own it. There'd have to be proof that he was negligent in allowing it to get out. The Warren Act is kind of a unique situation where Florida used to be a free-range state. The legislature said it's not going to be free-range anymore. You have to erect fences for your livestock. It defines what a legal fence is. And if you have one of those legal fences up, you're not liable unless you somehow negligently failed to maintain the fence. If you allowed the cows to get out by not maintaining the fence. The Southern Reporter is replete with cases addressing this. In this case, the facts are undisputed. Mr. Mazak said the fence was in perfect working order. I even inspected it the next day. The police officer said, no, I didn't see any defects in the fence. All the gates were closed. The fence looked fine. So it's not enough that one of his cows may have been out if we were to make the leap and assume this is his cow. And it's also, I've heard some implications, it's not enough that cows may have gotten out in the past. There's one case that talks about repeat cow escapes, and the reason it brought that up is because there was a fence that was in disrepair, and they said that the farmer should have known it was in disrepair because his cows had been going out through the hole or the down portion of the fence. So if the fence is fine, it's not enough that a cow escapes. There's plenty of cases, even a Florida Supreme Court case, saying it's not enough for a cow to be in the roadway. You have to show that there's something wrong with the fence that allowed it to be there. There's undisputed in this case that there's nothing wrong with the fence. Everybody who was there that night said it was fine. There's no additional witnesses or additional testimony that would change that either. Unless the court has any further questions, I simply ask that you affirm.
Thank you, counsel.
Thank you.
Mr. Medina, you didn't have any rebuttal time, but I would like you to step up to at least address the question of whether you noticed the case for trial.
Yes, Your Honor. I believe in looking at the record that we did notice the case for trial, and to Judge Swaya's question is, I wish that was the case, that when you're ready, you get it and you set, but quite frankly,
Yeah, but when you notice a case for trial and you file a notice, you're telling the court and you're telling everybody else, this case is ready, and set a trial date. We're ready to go.
Well, I think what is in reality, in the practice, it is that you're telling them to be ready so we can get set for mediation and then pretrial conference and so forth. That's what it is. And if I can just add one thing to the court is in the question of ownership, because I think there's been a misconception.
Wait a minute, I want to go back. When you notice a case for trial, doesn't that necessarily mean that the case is ready to be tried, and let's get the case set, let's get the pretrial conference, whatever we need to set to get the case moving, let's get the case set and ready for trial. When you file that notice, you're telling everybody you're ready.
No, I think what I'm telling you is I want to get on your calendar. And we're not ready at that time.
What happens if you file your notice and 2 weeks later the trial judge says we're going to try it?
Well, I wouldn't do that if I know we were coming up in 2 weeks.
Well, I mean, you don't know, do you? I mean, you're asking you're telling the trial judge, look, judge, this case is ready. We're noticing it for trial. We're ready to go. Set it.
No, what we're doing when you file that notice is to go down there and get on his or her calendar, and you pick a date, and then you pick a date.
But you don't ask the judge to put a case on the calendar unless it's ready to go.
And it was basically. Judge, that is our practice in my office, because if you don't get it in front, if you don't get on the trial calendar and you don't get it set for mediation, cases don't get resolved and they sit on everyone's docket.
Let me ask you this. When did you do the notice for trial?
I don't have that in front of me, Your Honor, but, typically the plaintiffs are the ones that set it for trial. That's why.
All right. When you noticed it for trial, was there a scheduling conference set where a trial date was set?
There was a status conference set.
And at the
that's
status
when all these
conference,
issues
did they
came up.
set a trial date?
Yes, sir.
Okay, and how far before the trial date was the status conference which set a trial date?
I believe that there was a status conference in, Your Honor, without looking, I'm not even sure we ever got a definitive trial date the second
Well, the
time
purpose
around.
of the status conference is to frame the issues, and you can't
Yes,
frame
sir.
the issues unless you've had your
And that's
discovering
what-
the cases.
And that's
ready
what
for
we
the-
told the
So how
court.
can you say that you weren't ready? You filed a notice for trial and you wanted a status conference. The status conference was to tell the judge, look, judge, these are the issues that are going to be tried. You go over your jury instructions, you go over all of these things at the status conference. So all that stuff is done, and the
I
trial
disagree.
judge.
The pretrial conference is where you go over jury instructions and things of that nature.
Well,
The status conference that was set was where we were, the continuum of readiness for the trial, and I believe that was December without looking at it.
Well, you can call it a pretrial conference or a status conference. The status conferences that I used to hold were conferences where a notice had been for trial had been set, and the judge says, "Come on in, let's make sure we got all our ducks in a row. What are the issues? What are we going to try? How long is the trial going to last? And that sort of thing."
Judge,
You
I
can
can just
call it a
tell-
pretrial or a status, but that's essentially what happens after you file a notice for trial, isn't it?
Right. Well, it depending on jurisdiction, but in my experience, and I've got about 100 jury trials under my belt, is that you set it for trial to get on the docket, to bring it to the attention of both the defendants and the court to get dates, because if not, you're not going to get on the court's docket.
Let me ask you, on the scheduling conference, and I'm familiar with what you're describing, but at that scheduling conference, it's usually months in ahead, and the judge says, when will you be ready for trial? And the two attorneys say, we'll be ready next October. And they say, okay, when do you want to mediate by? And the attorneys give input, and the judge sets a cutoff date for mediation, and the judge sets a cutoff date for discovery. And so my question to you is, did you have this type of scheduling conference where the judge gave you cutoff dates for
this
discovery
district.
and trial, et cetera?
Not this judge, not this jurisdiction.
Because my understanding was that the summary judgment hearing was subsequent to the date the trial was initially scheduled for.
Yes, sir. But what I'm saying is most jurisdictions, you're right, they'll have that, and you'll have a discovery plan, and much like in federal court where you'll have, hey, this is expert discovery, lay discovery, all these things have to be dispositive motions. She didn't have any of that in her
But
schedule.
you did have a trial date,
Yes, sir.
and that was months before.
Yes, sir. And then we
Summary
ran into
judgment
these
hearing.
discoveries issues, and that was also, in between my illness, and I should have taken it off the calendar probably in retrospect, but again, just not to take up the court's ownership.
But in order to get a status conference, you don't necessarily have to file a notice for trial, do you? You can ask for a status conference
You're right.
by filing a motion and asking the judge for some time.
Right.
When you file your notice for trial, you're telling the judge that you're ready, and let's go ahead and set it. And then after that, you have a hearing with the judge, and you frame the issues. You can call it a status or a pretrial, but essentially, once you file that notice, the trial judge wants to know, let's set it for trial, and what are the issues, what are we going to discuss, what are the jury instructions, and that sort of thing. You
Again,
don't
Judge,
need that.
in practice, that's just not the way, and in a lot of jurisdictions, that's just not the way it's happened in my practice.
So you're saying then that you necessarily have to file a notice that the case is ready for trial so you can get a status conference?
You can ask for a status conference, and I'm not, where the judge is
Right.
going to give it to you, I'm not sure, but, I think, and in my practice, and in almost every jurisdiction I practice in this state and others, in 9 others I practice in, is you set a motion to get, set cause for trial, and the parties agree, and you move towards, just like in federal court, which is you work back from your trial date and try to get your
Right.
discovery done.
Right, okay.
And we didn't do that. If I could just say something on ownership,
No, you're
Judge
way over
Palmer.
time. You're way over time.
All right, it's just,
Court will be in recess.
All right, thank you.